There's a pattern showing up in enforcement cases across the country, and it's costing clinic owners everything. A medical director on paper, someone who signed the agreement, took the retainer, and never stepped foot inside the clinic. States are now actively flagging this arrangement. Compliance and legal experts in aesthetic spaces are calling it one of the highest risk structures operating in the med spa space right now. And the consequences are not just fines. We are talking license revocations, forced closures, and in some cases, civil liability that follows the clinic owners personally. If you have a medical director on paper and you're not sure what their actual involvement looks like day to day, this video is for you. The American Med Spa Association published a case study about an Illinois med spa owner. They called him Mr. Hansel, and his medical director, Dr. Zoolander, a newly licensed plastic surgeon. Both of them walked into a CPOM violation, not because they were being reckless, but because they did not know what the corporate practice of medicine doctrine actually required from their agreement. That case is one of the dozens being documented right now across the country. I found it so you don't have to go digging. Here is a thing that surprises most clinic owners when I bring this up. They say, "We have a medical director. We have an agreement. We are covered." But the cases compliance professionals are currently reviewing show that having the agreement is not the issue. It's what the agreement actually requires the doctor to do and whether they are doing it that's actually getting clinics shut down. Today we are covering 3 things. First, what the ghost director pattern actually looks like and why it keeps showing up. Second, the specific compliance gaps that turn a medical director agreement into a liability. And third, and this is the piece that most clinic owners never hear about, what a properly documented medical director relationship actually looks like and what you need to have on file to demonstrate it. Stay with me because that third piece is what separates clinics that survive an investigation from ones that don't. Let me start with what is actually being reported out there because this is more widespread than most people realize. In the summer of 2024, New York City launched a joint investigation into med spas across all 5 bureaus. Investigators from the Department of State, the Department of Health, and the City Council's Oversight Division walked into 15 locations. What they found was documented in a report released in December of 2025. 4 of those businesses lost their licenses and their ability to legally operate. The violations included performing medical procedures without proper medical oversight, which is exactly the structure we are talking about today. But it's not just New York. In December of 2025, an Arizona med spa nurse was publicly reported for offering prescription medications without proper physician oversight. Same pattern. Provider operating outside the oversight structure their agreement was supposed to provide. And in September of 2025, the Alabama Board of Medical Examiners issued a formal action, documented and reported by the American Med Spa Association, that highlights what happens when the oversight piece breaks down at the state board level. These are not isolated incidents. Compliance professionals across the country pointing to this as one of the most commonly reviewed issues when a clinic gets flagged. But here is what all of these enforcement actions have in common. And it's probably not what you think. It is not that these clinics have no medical director, most of them had one. The problem runs deeper than that. The CPOM doctrine, the corporate practice of medicine, exists in some form in most states. And what it generally requires is not just that a physician is named on a contract. It requires that a licensed physician maintain actual clinical authority and meaningful oversight over the medical services being provided at the clinic. The compliance gap that shows up over and over in these cases being reported looks like this. The medical director signed the agreement. They may have done one site visit at the beginning. They are not reviewing charts. They are not available for consultations. They are not physically present in any meaningful way. They are a name on a document and nothing else. Compliance professionals have a term for this. They call it the ghost director arrangement. And here is why it is dangerous. When an investigation or a board complaint opens against that clinic, the first thing regulators look for is evidence that the medical director was actually directing. Chart review signatures, visit logs, standing orders reviewed and updated, and communication records. If none of that documentation exists, and often it does not, the physician faces board action and the clinic owner faces the legal exposure of having operated a medical practice without actual medical oversight. The Medspa case study about Mr. Hansel and Dr. Zoolander illustrates this directly. Their agreement did not comply with Illinois CPOM requirement, not because they were trying to cut corners, but because neither of them fully understood what meaningful oversight actually required in their state. This distinction matters because it means that there's a knowledge gap problem, and it's costing people their businesses. Now you might be thinking, okay, so I need a more involved medical director. But here is where most clinic owners stop short, and it's the part that actually creates the paper trail that protects you. When compliance professionals describe what a properly structured medical director relationship generally looks like, a few things come up consistently. First, physical or documented virtual presence. The medical director should have a defined schedule of engagement, whether that is weekly chart reviews, monthly site visits, or documented telehealth meetings. It needs to be written into the agreement, and it needs to actually happen with proof. Second, standing orders that are reviewed and signed on a regular cadence. Not once at the start of the relationship, but regularly, with dates. The standing orders govern what your staff can do or under what conditions. If they have not been updated in 2 years and something goes wrong, that gap becomes evidence. Third, a documented communication structure. If your medical director is not reachable for clinic questions, that is a supervision problem. What compliance experts generally recommend is a clear protocol for how clinic decisions get escalated, and records showing that protocol is being followed. Fourth, a chart review documentation. In most states, this is one of the most commonly reviewed items during an investigation. The medical director should be reviewing patient charts on a defined schedule, and that review should leave a documented record. Oregon made a significant move here in June of 2025. Senate Bill 951 went into effect and actually expanded CPOM restrictions, specifically closing what were called friendly PC loopholes that had allowed non-physician entities to exert influence over medical practices. It's a signal that states are tightening up on, not loosening. Knowing what it should look like and actually having it documented in a way that holds up during a board review, those are two different things. And this is where most clinics are still exposed, even when they think they are covered. Here's what needs to be in place and what needs to be actively maintained for a medical director relationship to be defensible. Start with the agreement itself. It needs to specifically define what oversight looks like: visit frequency, chart review cadence, standing order review schedule, and availability requirements. A generic agreement that says physician oversight provided is not enough. The specifics are what protects you. From there, you need an ongoing documentation system. This is not about paperwork for paperwork's sake. It's about having the evidence that oversight actually happened. Visit logs, chart review records, standing order updates with date, and communication records between the clinic and the medical director. Most clinics do not have this in place, not because they don't care, but because nobody told them this was the standard being applied when investigations happen. The clinics getting through board reviews and enforcement actions right now are the ones who built this documentation system before they needed it, not the ones scrambling to find records after a complaint was filed. So I told you at the start that the piece most clinic owners never hear about is what a properly documented medical director relationship actually looks like. This is what we just walked through. And if you found yourself nodding along and thinking, we don't have most of this, you are not alone. This is the reality in most of the clinics compliance professionals are currently working with. Here's the truth about the ghost director problem. It is not really a physician problem, it is a documentation problem. These clinics getting shut down are not necessarily the ones with the worst medical directors. They are the ones that cannot prove the relationship was real. Compliance is not about having the right people on paper. It's about building the evidence that those people are actually doing what the law requires. If you want help building that documentation system and making sure your medical director relationship actually holds up to scrutiny, this is exactly the kind of work we do at ACE. You can find the link to contact us in the description below.